pleased to be here. My name's Janet Butler-McPhee. My pronouns are she, her, and I'm one of two co-executive directors at the HIV Legal Network. So, not to be confused with HALCO, which I know a lot of people do, we are a human rights and justice organization. We're about 33 years old, and we're born of the HIV movement. We promote the human rights of people living with HIV and AIDS, but also other populations who are disproportionately affected by HIV, punitive laws and policies, and criminalization. And we do this work, as Amy said, in Canada and around the world. We do it through kind of a combination of research analysis of litigation, so going to court on specific cases, advocacy, public education, and community mobilization. In Ontario, you may be familiar with the HIV and AIDS legal clinic, so HALCO for short. They're different from us because they are a frontline legal aid funded organization designated specifically for people living with HIV. We are an advocacy group, so a little bit different. Okay. So today we're going to talk about first the context of in which HIV criminalization happens, a little bit of the history about where it came from. We'll talk, the bulk of the presentation will be specifically on the state of the law in Canada and the impacts of criminalization, and particularly on women. And then I'm going to tell you what I hope will be some welcome news about law reform, and we'll leave some time at the end to have some questions. Okay. I want to also be clear, as you probably gleaned from my bio, I'm not a lawyer. In fact, I was in law school for about 2 months back in the day before I realized that actually communications and advocacy was more my thing. So, as any lawyer would do, I will also give you this information. What I'm about to tell you is legal information, so it's very general. Legal advice would be specific to something that you might bring forward or your situation. And so those types of questions, for example, if you're in Ontario, could be answered by colleagues at HALCO. But if you have specific questions and you're outside of Ontario, I'm really happy to hear from you afterwards. I'll give you my email and we can see if there's any legal advice you may need elsewhere in the country. Okay. So in Canada, more than 65,000 people are living with Canada, but the vast majority of people living with HIV are diagnosed, and those diagnosed people are on treatment, and 95% of people on treatment have a suppressed viral load. We just actually did a report last year, and one of the most startling findings was how big the disparities were with new diagnoses, and Manitoba and Saskatchewan are leading multiple-fold in terms of new diagnosis in our country. So you may also have heard recently that Manitoba declared a state of emergency around this, and that is very much in keeping with what we know to be true right now about the rising cases in that province. I'm probably not going to tell you something you don't know here, but viral load is important when we talk about the context of HIV criminalization, because it is used in law to distinguish when people do or don't have to disclose their status. So when I talk about suppressed viral load, I'll be talking about 200 copies per milliliter of the virus. Undetectable viral load, I'm sure everyone's heard about U equals U, undetectable equals untransmittable, and that's 50 copies or fewer per milliliter, and low viral load, which is 1,500 copies per milliliter. And that is important because that's the legal benchmark that was set by the Supreme Court of Canada in a case more than a decade ago now. It's also important to talk about who criminalization is affecting in Canada. So, and who new cases are happening to. So obviously, we have men who have sex with men. We have a lot of heterosexual transmission right now in Canada. We also have higher rates in people who inject drugs, and that is particularly important when we talk about women, because there is a lot more cases in women amongst people who use people who inject drugs, And as we all know, for lots of reasons, including colonization, including racist laws and policies, including lack of access to healthcare, Indigenous and Black communities are very disproportionately affected by both HIV and by HIV criminalization. And no news here, people living with HIV still face pervasive stigma and discrimination in their daily lives. So when we talk about HIV criminalization, we're talking about the fact that in Canada, people living with HIV can be charged, prosecuted, and imprisoned for not telling their sexual partners their status, their HIV positive status, before sex that poses a realistic possibility of transmission. And that realistic possibility is important when we talk about law. Many countries around the world criminalize people living with HIV. In some places, they have HIV-specific laws, so HIV is actually in their code of law. But in Canada, we use general criminal laws. There is no specific HIV offense. We use, in Canada, unfortunately, the laws of sexual assault to prosecute people living with HIV. In 2025, our colleagues at HIV Justice Worldwide told us that they have documented at least 112 arrests around the world for people for alleged non-disclosure. In Canada, more than 200 people have been charged since the 90s. We used to be a global leader in prosecutions against people living with HIV. It's changed in recent years because of we'll talk about this a bit more, but there's prosecutorial guidelines and new charges are less and less frequent. Now, I want to say that doesn't mean that people don't live with the threat of criminalization and all the harms associated with just the threat, the idea that you could be prosecuted. And, you know, that in and of itself is more than enough harm that we should be removing laws that criminalize people living with HIV. So in Canada, most of the cases are actually heterosexual cases where men are having sex with women. Only 19 women have been charged to date in Canada, and of those, a very high percentage have actually been Indigenous women who've been charged. You can see that Uzbekistan, Russia, and the United States have the highest levels of prosecution right now. We're also seeing that in Senegal, just this year, people who identify as LGBTQ+ have been prosecuted, rounded up, and forcibly tested for HIV. So we can see that this criminalization of HIV non-disclosure is very much still an issue. Very briefly, HIV criminalization started in the US, but quickly came to Canada. It basically was started at a time of real moral panic, of lack of understanding, of people just not understanding how HIV was and wasn't being transmitted, and before, obviously, people had access to treatment. So about the same time it was starting in the US, we were seeing cases come up in Canada. And like I said before, after 3 decades, we used to be a world leader. We are not that anymore, but we don't have a very proud history in this regard. We have prosecuted many people, and people still live with these laws, with the threat of prosecution in Canada. So in Canada, like I said, there's no specific law or article that says if you don't disclose your HIV status, you can be prosecuted. We use other laws and statutes within the criminal code. We use the laws of sexual assault. And what people are usually charged with in Canada is aggravated sexual assault. So normally that is a very serious charge that is reserved for things like rape with a weapon. So it is very mismatched, even when we think about just what is being used. The law of sexual assault was not meant for this purpose and is really being misused against people living with HIV. So a lot of people ask us, when is HIV disclosure legally necessary in this country? And it's a really good and really complicated question. So in general, you have privacy rights, but when it comes to sex, things get more complicated. The legal obligation to disclose one's HIV status to a sexual partner first was established in a couple of cases called Courier and Mabior. And those are only important because they set the precedent. They set the precedent for what is required now, and kind of the lingering effects of these cases are how we think about HIV criminalization now in Canada. So it's not legally required in every case of sex. Like I said before, it is legally required in sexual activity where a realistic possibility of HIV transmission occurs. And that's the court's definition, realistic possibility. This is where it gets complicated, because what is a realistic possibility? And we'll see that this is how the court talks about realistic possibility. I want to say up front, this is not how scientists, how doctors necessarily talk about realistic possibility. This is what the law says. In Canada, the law says that if you use a condom and you have a low viral load, so fewer than 1,500 copies per milliliter, you don't have a realistic possibility of HIV transmission, and therefore there is no need to disclose. So that the court thinks maybe is clear, but it is certainly not that clear for people living with HIV. Science talks about things a bit differently. So expert scientific consensus statements, when scientists, including actually Dr. Mona Lutfi, who's at Women's College Hospital, who I'm sure you all know, scientists, doctors, and experts came together in Canada first in 2014 to say, hey, courts of law, you're interpreting the science incorrectly. And the science around HIV transmission is not... We're going to give you a framework to think about when HIV can and can't be transmitted, so that next time there's a criminal case, you can look at this and try to think about realistic possibility in those terms. And then, of course, there was an international statement that followed on what the Canadian experts said in 2018. So they talked about scenarios where the possibility of transmission of HIV was basically zero or negligible. And so they talked about the combination of condom use plus low viral load, a suppressed or low viral load just on its own, condom use alone, no chance in oral sex, and no chance in biting or spitting, because we have seen people make problematic statements about how biting or spitting might be a means of transmitting HIV. So these experts, doctors, everyone got together and said, courts of law, you need to understand from a public health perspective that HIV is not transmitted nearly as efficiently as you think it is, or as the law recognizes it to be. Instead, it's actually really hard to transmit. In all these scenarios, the chances that someone living with HIV would pass on the virus are no chance or negligible chance. So here we are in 2025. We've had court decisions, we've had experts weighing in, but the courts still haven't defined what that realistic possibility of transmission means for different types of sex. And some provinces and territories have put together what we call prosecutorial guidelines. So prosecutors are the ones who would take up charges, prosecute charges against people living with HIV. And in, for example, Alberta, BC, Ontario, Quebec, and at the federal level, we see prosecutorial guidance. Okay, and usually that guidance is because advocates have said the law is not keeping up with science. We need you to do better as prosecutors and think more critically and put some guidance on this so that we're not harming people living with HIV as broadly as we are. You know, it'd be great to first remove the law, but the next best thing we can do is put this fencing in the form of prosecutorial guidance. So whether a person needs to disclose their status actually depends on the province or territory that they're in and the type of sex that they're engaging in. And that's why this is so complicated. So let's talk first about suppressed or undetectable viral loads. So the general rule that was set by the Supreme Court of Canada that we talked about before said that a low viral load plus condom use was what you needed to do. So you needed to do both, is what the Supreme Court said. But in some provinces or territories, including Ontario, people living with HIV don't, I'm sorry. Someone just knocked on the door here. Sorry about that. They don't have to disclose if they have a suppressed or undetectable viral load, even if they have sex without a condom. Okay? So in some provinces, they've given guidance saying actually a suppressed or undetectable viral load is enough. You don't need actual condom use as well. So we're not going to prosecute people living with HIV if they are suppressed or undetectable. Then if we talk about condom use, so the general rule again set by the Supreme Court was that people living with HIV have to disclose to their partners, even if they use a condom, unless they also have a suppressed or undetectable viral load. So again, condoms alone were not seen as sufficient. You can see that this again differs from province and territories. So prosecutorial policies in BC and in the territories say that condom use could be enough, but we're not quite sure. In Ontario, though, someone was convicted in 2020 despite using a condom because he didn't have a low or undetectable viral load. So the law says one thing, we have some guidance, but we're not quite sure what that guidance could mean. Condom use can be a little trickier for people. Oral sex. The general rule is that engaging in oral sex on its own doesn't mean that a person can be prosecuted for non-disclosure. But in 3 territories and in British Columbia, the prosecutorial guidance, so that fencing we talked about, say that they will generally, and they use the word generally, avoid prosecuting for oral sex, but they don't guarantee it. So again, that word generally is doing a lot of work there. In Ontario, even if you only have oral sex, unless your viral load is suppressed or undetectable, there's still a risk of being prosecuted or convicted. Using a condom for oral sex might reduce the chance of being convicted, but we don't know for sure because there haven't been any cases on that. People always ask us for kind of for lack of a better way to say it, tips and tricks to avoid risk of criminalization. I want to say up front that it is terrible that people living with HIV have to think about this. It is not just. There is nothing justice related in this. And many of these tips are completely unrealistic in many scenarios. So as I go through them, please know that that's the caveat. No one living with HIV, people should not have to think about this. But people do ask. So what I would say is clear disclosure before sex, so no coded words. For example, the word pause or positive may not have meaning to someone who isn't living with HIV. So that could be considered a coded word, and that might not be helpful for you when you're trying to prove disclosure. Obviously, seeing your healthcare provider regularly to getting and keeping your viral load as low as possible is key. Some types of sex have lower or no risk of transmission. Penetrative sex is obviously is different, for example, and treated differently than other forms of sex. The use of condoms, and I guess not assuming that people know that you are living with HIV, even if you have disclosed, if you feel like it's a reasonably public thing that people, know that you're a person living with HIV. Don't assume that a partner knows that information. We tell people to save disclosure conversations, including if they're in the form of emails or text messages. Disclosing in front of a witness, including a doctor, for example. And again, I go back to that caveat of that may not be practical or realistic. These are just ideas. And we've even had people tell us that they have signed documents and or recorded a video before sex with their partner, recording the disclosure. So, why is this so problematic? So many reasons. First of all, it's at odds. HIV criminalization is at odds with medical evidence. We know that the law has not kept pace with science. It has not respected the importance of condom use and how difficult HIV as a virus is to transmit. And like we talked about before, in Canada, though prosecutions have gone way down, people remain at risk of criminalization, so remain under this constant threat of criminalization, even if no prosecution ever happens. And you're at risk of criminalization even if you have no intent to transmit and HIV was not actually transmitted. So it's a very kind of treating people living with HIV as if they are criminals, and living with that and navigating a sex life through that is blatantly discriminatory and unfair. And as we've just spoken about, there really is an unclear legal standard. So depending on the province or territory, depending on the type of sex you're having, it leads to uncertainty about when or not people have to disclose. And we all know disclosure is exceedingly difficult and comes with its own risks. We also know that HIV criminalization discourages people from getting tested and knowing their status. We don't actually know, though, for example, if not knowing your status could be used as a legal protection. That hasn't been tried. So we don't actually know if that's if not knowing your status or not getting tested for fear of criminalization could be helpful in avoiding criminalization. It can impede communication with health professionals because although many conversations are meant to be protected, there's not a guarantee that a healthcare provider won't be called to court to testify. It doesn't improve health outcomes, and it really, I think one of the most important things is for women, there is a very gendered experience of HIV criminalization that is really important to talk about. It can have to do with power dynamics in relationships. So, for example, if a woman is living within an abusive relationship or in a relationship where there is a huge power imbalance and disclosure could lead to violence, this is a really difficult situation for women to be in when they feel that it's unsafe for them to disclose. And we have had cases like this. We actually had a case at the Supreme Court of Canada called DC, so the initials DC, where a woman was in an abusive relationship. It was a good relationship at first. She was living with HIV. It turned abusive, and essentially the partner said, if you go to the police, I will tell them about the abuse. I will tell them that you didn't tell me that you were person living with HIV. So it can be used in really manipulative, and obviously that's not unique to women, but we certainly worry about it in the context of intimate partner violence. Another thing that happens is if someone is convicted in Canada of HIV non-disclosure, they become a registered sex offender. So they are put on a sex offender registry list, and that would also have implications for them being able to access care and help at a violence against women shelter, because typically those shelters don't allow for people who are on the sex offender registry to access their services. So a really difficult, complex, and unfair use of criminal law. And again, this is one of the questions that we get a lot, and it's what if I can't disclose my HIV positive status because I fear violence or retribution? And like I said before, it's really unclear whether these fears would be accepted as a legal defense. We imagine that it would be taken into consideration, but certainly there's no definitive court decision that would be helpful in knowing this. If this is a fear for you, a legal clinic like HELCO, or you can contact the HIV Legal Network, and we can talk through whether there are lawyers pro bono or otherwise in your jurisdiction that could help you untangle this in a manner that's safe for you. This is a really awful question to have to answer, and that is, can I be charged for not disclosing my HIV status if I was sexually assaulted? And one of the most, obviously, it's a horrible question on its face, but the truth of the matter is we don't know. The idea that someone would be concerned about reporting a sexual assault because in the moment of that sexual assault they had not disclosed their status is horrific to think about. But to date, there has been no ruling from a Canadian court on whether people living with HIV would have to disclose to an assailant. Ultimately, that would be a judge's discretion. Again, if this is a situation in which you find yourself, this would be a really important time to seek legal advice. I want to also say that, at the Legal Network, we've produced a couple of documentaries, including Positive Women Exposing Injustice and Consent, HIV Non-Disclosure, and Sexual Assault Laws. They're online and available for free to watch. I'm happy to pop them into the chat if people want to take a look. But I think acknowledging the very specific impacts on women is important in the context of HIV criminalization. And actually, the UN Committee on the Elimination of Discrimination and against women, all forms of discrimination against women, has recognized this more than a decade ago, that this that criminalization and criminalization in the context of Canadian law has particular important and very harmful impacts on women. So this is not just something that advocates are saying, this is something that UN level bodies have said is wrong. What I want to leave you with at the end of this, I know that's a lot to digest, but I want to leave you with a couple of positive things. So first, in Canada, as I've mentioned before, we've seen a marked decrease in the number of cases, and I think that's because of the advocacy of people living with HIV, of organizations that have long recognized that this is wrong, and of medical and other experts who have clearly come forward and said what we're doing is a perversion of the law. It should never be used this way. There has been a recognition from the Government of Canada about the over-criminalization of HIV non-disclosure, and that recognition is also more than a decade old. And finally, there's also growing recognition that a suppressed viral load, so not just an undetectable viral load, should not lead to prosecutions because, like we talked about before, the chance of transmitting the virus is negligible or nil in those situations. And there's a lot of people working on law reform right now. So there's a coalition called the Canadian Coalition to Reform HIV Criminalization. If you've not heard of it, I'd encourage you to take a look. There's some really good resources on the webpage, and we're always looking for people, particularly with lived experience, to be part of the group. We put together a community, what we call a community consensus statement in 2022, and the goal was to end the overuse of criminalization, especially where there's no possibility of transmission, which is the vast majority of cases. And we had 4 demands that we were making. The first was to remove HIV non-disclosure from sexual assault law because it is not sex assault. Limit prosecutions to intentional and actual transmission. So the idea would be a person would have to intend and actually pass on HIV. Ending deportations for non-citizens. If non-citizens, including permanent residents, are convicted for aggravated sexual assault, they will be deported normally because that is a serious offense. And to review past convictions. So like I said, there's a number of people, because of all the prosecutions that Canada has done, who find themselves still on sex offender registries, which has incredible and harmful impacts on people's lives, and for the rest of their lives. In November 2024, the Government of Canada said it wasn't going to move on this. But in 2026, we're actually seeing some renewed engagement at the federal level and looking at the possibility of a bill to change the law in Canada that could be introduced in Parliament as early as December of this year. Now, will it move as quickly as we want it to? I seriously doubt it. This should have been done a long time ago. But the idea that the government now is serious enough about the harms that are hanging over people living with HIV constantly in this country, the idea that they are aware of that and looking towards movement into a better direction is really encouraging. So hopefully, if I come back to speak again, we'll have better news for you, and we'll look at something that would remove a lot of these harms. I also wanted to point out a few key resources that we have. These are all available on the HIV Legal Network.ca website. So the first is a general Know Your Rights on HIV criminalization. The other 2 are specific. One is a Know Your Rights that is specific to African, Caribbean, and Black women living with HIV who maybe also are affected by intimate partner violence, so disclosure and HIV criminalization in that context. And the second companion to that would be for Indigenous women who are living with HIV and affected by intimate partner violence. And I would say they're all very, as clear as we can make it, given the lack of clarity in the law. And so I hope you'll take a moment. They're available in English and French, and I think Swahili and several Indigenous languages as well, and Arabic, if you want to take a look at those. Like I said, I'm not a lawyer. I'm happy to answer any questions as much as I can right now, but just really happy to be with you discussing this important topic. Thanks so much.